Hello everyone, I am Anuj Nakade and you're watching Livelaw. The Supreme Court on Friday, the 4th of August, issued a call to action to stakeholders such as the police administration and the government to find an enduring solution to the problem of hate speech. The call to action was made while the Supreme Court was hearing a plea against the rallies and protest marches organized by the Vishwa Parishad and the Bajrang in various parts across the National Capital Region in the wake of the communal violence in Nuh and Gurugram, Haryana. The regular viewers of our channel might remember that on Wednesday, an application was mentioned before the Constitutional Bench by Senior Advocate Singh seeking the urgent listing of a matter regarding hate speech. The application was filed by one Shaheen Abdullah, fearing that the rallies organized by the Vishwa Parishad and Bajrang as protest marches against the violence in Nuh would lead to escalation of violence in these rallies. His application stated, and I quote, "Given the fact that the situation in Nuh and Gurgaon continues to be extremely tense and even the slightest provocation could result in a serious loss of life and damage to property, rallies that are likely to fan communal fires and incite people to resort to violence ought not to be permitted." The application was filed in an ongoing matter regarding hate speech in the country. The applicant is the petitioner in the hate speech case. On the same day, a special sitting of a bench led by Justice Khanna refused to stop the rallies or protest marches, but it urged the authorities to ensure that no violence breaks out and that there are no instances of hate speech during the processions. The court also issued directions to use CCTV cameras where they have been installed and make video recordings of the rallies in sensitive areas wherever required and preserve all the footage. The order of the court reads, and I quote, "Wherever required, adequate police force or paramilitary forces will be deployed. Further, authorities including the police will take use of the CCTV cameras where installed or make video recordings in all sensitive areas wherever required. The CCTV footage and the videos will be preserved." The court also directed the registry to communicate the order to governments of Uttar Pradesh, Haryana and the National Capital Territory of Delhi, and then adjourned the matter to be heard yesterday on the 4th of August. A two-judge bench of Justice Sanjeev Khanna and Justice S.V.N. Bhati heard the matter, and during the hearing, they urged the parties to adopt a constructive approach to find out a solution. Highlighting that the difficulty lay in implementing and executing the law on hate speech, Justice Sanjeev Khanna suggested appropriately sensitizing the police forces to ensure that victims of hate speech could access meaningful remedies without having to come to the court. He said, and I quote, "Why don't you all sit down together and find a solution? One difficulty is that the definition of hate speech is fairly complex, and how to understand hate speech within the parameters of free speech. We have enough definitions in several judgments. That's one issue. But the main problem is not the definition, but the implementation and execution aspects. You will have to think about that. The police forces need to be sensitized in order for these matters to be resolved." The Solicitor General of India, Tushar Mehta, while clarifying that he was not in any way condoning the instances of hate speech by any community or person, argued that the petitioners had prematurely approached the court without pursuing the remedies available to them in the law. He said, and I quote, "The law has been clarified in Tehseen Poonawalla. No one can justify hate speech by community A or community B. I am also not doing that. If there is any violation of law, the remedy would be to file an FIR. If FIR is not registered, you have to approach a competent court. Now, the practice that has developed is two practices actually. They come to the Supreme Court in contempt petitions, seeking directions from the Supreme Court. Now a step ahead, before any organization or any person organizes a function, they are coming to this court seeking an advanced ruling so as to ensure that no offense is committed." However, Justice Khanna interjected the Solicitor General and said, and I quote, "There is a little problem. The law on hate speech is complex. As far as execution or implementation is concerned, everyone cannot be coming to the court." To this, the Solicitor General said that the applicants are coming to court. In response, Justice Khanna emphasized on the lack of sensitization among the police forces about this issue. He said, and I quote, "The police forces need to be sensitized in order for these matters to be resolved. On that, we would require your assistance. Secondly, it is not in anyone's interest that there exist such social tensions." The Solicitor General agreed, saying that it is only in the interest of the country, not just the communities. He then continued, stating that the difficulty is that the petitioners or applicants approaching the Supreme Court were, quote, selective to subversive ulterior motives. He said, and I quote, "The petitioner stays in Delhi, hailing from Kerala, and filed petitions only for Maharashtra, only for one community." However, Justice Khanna clarified to the Solicitor General, and I quote, "We are not going into that." Senior advocate C.U. Singh, appearing for the petitioner, interjected at this point and said, and I quote, "This is not an adversarial litigation. The thing is, it is not just hate speech. These are almost calls for genocide." The Solicitor General responded to this, stating that he wants to share similar speeches with the counsel for the petitioner, and then the petitioner could amend his petition to include them. He said, and I quote, "There are some lawyers who give me clips. The speeches in these clips demolish the very vital fabric of our country, which is secularism. I will ask these lawyers to share the videos with Mr. Pasha, the petitioner's counsel, so that he can place them before this court. Selected people come to this court with selected prayers." Advocate Nizam Pasha replied to this, saying, and I quote, "The reason why we have to approach the court again and again is because when the police refuses to register first information reports, there is a procedure in law. But when same people meanwhile are making hate speeches again and again, and you see the consequences, speeches are asking one community to leave the state or an area." The Solicitor General retorted, saying, "Exactly, I will share such videos with Mr. Pasha. I want to see your bona fide. I am making this clear." Urging the parties to adopt a constructive approach, Justice Khanna said, and I quote, "One thing is to look at the past. One thing is to look at the future." But the Solicitor General protested, saying, and I quote, "Past events are necessary to decide the future. I will take this court through these events." At the end of the exchange, Justice Khanna said that there needed to be a solution which allows victims of hate speech to access justice without having to come to the court. He said, and I quote, "There has to be some way in which we can deal with this problem. Everyone should not be coming to the court. In case there is any infringement, even in the last order, we specifically said that all identities, everyone, should be covered." The court has now listed the matter after 2 weeks, and we intend to bring you prompt updates from the court as fast as we can. If you found the video informative, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Don't forget to subscribe to our channel and hit the bell icon for notifications. If you would like to support the work we do here, please consider becoming a member of our channel for only ₹89 per month. Thank you for watching.